So we are here today. We're going to talk to how to file a claim in a Camp Lejeune case. It's what we're working on. We're filing administrative claims. We have a bunch of clients from around the country, I think 15 different states, and we are in the process of filing a claim, and we want to put some information out. What does that mean? What does that mean for our clients? And we're going to answer some of the basic questions. So let's go through it.
All right. So who qualifies for filing a claim?
Basic person who can file a claim in a Camp Lejeune case. You had to have been at Camp Lejeune for 30 days between 1953 and 1987. You have to have had exposure to water there and have a illness related to toxic water exposure.
Okay. So can you tell me about the process of filing a Camp Lejeune lawsuit?
Yeah, so a Camp Lejeune lawsuit, it's under the PACT Act. The law went into effect August 10th of 2022. You need to have a lawyer, and the process is kind of, I would think of it as like a three-step process. You need to have a lawyer. In my opinion, you have to have a lawyer. The first step is really talk to someone who is handling these type of cases, and then you have to file an administrative claim with the government, and that's going to be the Department of the Navy. The Department of the Navy essentially controls Camp Lejeune, and that notice of claim, we're going to talk a little bit more about the administrative claim or notice of intention to file a claim. We're using some different terms interchangeably. The government then has 180 days to respond, and if they don't or they deny the claim, you can bring a formal lawsuit in federal court. It has to be brought in the Eastern District of North Carolina.
Okay. So tell me a little bit, what is the administrative claim process and then the court claim process? And like those are different? What is that?
Yeah. So it all starts with, are you an eligible claimant? And the notice of intention to file a claim is what I call it, or the administrative claim. Sometimes it's called a Form 95. That's going to lay out the basics of this is an appropriate person to file a claim. And it's going to say, what's the person's name? When were they at Camp Lejeune? What was their water exposure? Was it due to where they lived, or was it due to what their job was, or did they go swimming in the pool or drink water? What was the toxic exposure? And then what illness was caused, or what illness are we claiming was caused due to that toxic exposure? And then what damages has the person suffered because of their exposure to the toxic water? So the claim form, the 95, lays all that out to the government, and then they can do their own investigation. That's the point of the administrative process, to give notice to the government.
Okay. And that's the court of claims process too.
Yeah, that's the administrative process. And then at that point, we don't believe that we will successfully resolve all of our cases at that point, and maybe not any of the cases at that. If you cannot, then you file a more traditional lawsuit in federal court. You go through the formal court process, discovery, pleadings. You make a formal complaint. They answer the complaint, presumably deny the complaint, and there's an exchange of information between the sides about this person and this situation. There's arguments to judges, and eventually you're entitled to a jury trial.
Okay. And so that's kind of the point of reaching a settlement, and then how settlement amounts and payouts are determined, right, is through this process.
Yeah, so we're always looking to resolve cases fairly and quickly. A lot of our clients are older people. They're not going to live forever. They don't want to go to North Carolina. They don't want to be deposed. They want, everybody knows what happened. Some of the people, the VA has already accepted their claims, and they have toxic exposure for years. They have illnesses clearly related to toxic exposure. In my opinion, those cases should settle. We should be able to come to an agreement and resolve the cases. And it takes both parties to want to settle, and we want to do that. I think there will be a question as to the value of the cases.
Okay. And then what is some of the documentation that some of these individuals would have to fill out, like a claim form, or what is something that
Yeah, so the
How
attorneys are
much
going to
paperwork is there?
the attorneys are going to fill out the claim form, but the documents are important, and the documents are going to show two things. The person was at Camp Lejeune, and the most likely way to show that is through a form called a DD 214. DD is Department of Defense 214. There's also a form 118 that shows people signing in and out of Camp Lejeune, but we can also show photographs of people at Camp Lejeune. We can show letters addressed to loved ones, either addressed to them or from them. We just have to prove that they were there. So those are some of the documents that show they were there. And then typically medical records would be used to show the illness.
Okay. And what are some common questions that people call and ask about when it comes to Camp Lejeune?
Yeah, I think in regards to filing a claim, they want to know, one, do I qualify? So just to kind of recap that is, were you there between 53 and 87? And you can bring a case on behalf of someone who's deceased. We have to do an estate, so probably 25% of our cases.
That's an extra step in the process.
We have to get an estate set up. It's an extra step, but it's a lawyer who's going to file to open an estate or reopen an estate. Was the person there? Did they have water exposure? Can we show that they have an illness related to toxic exposure? That's, the number one question is, do I qualify? And then the next question is, what's the process? The process is, connect with an attorney, file the administrative claim, and then presumably 180 days from now, go to federal court. Work towards a settlement, work towards a trial. That's something that we'll talk to our clients about, what's best for them. But I think generally most of our clients, they're not looking for a trial.
Right.
I don't predict a lot of trials in this case. I think there will be some preliminary trials to flush out legal issues, and then those lessons will be applied to thousands of people who never have a trial. And then the big question is settlement amounts. That's we've done separate articles and blogs on settlement amounts, but just as a high-level understanding, settlements amounts are going to be determined by, in some cases, trials. Jurors are going to say, this is what we believe the pain and suffering for someone who had a very serious illness like cancer would be. And then you look at other cases, whether it's paraquat, mass tort situations where there are people who have had cancer cases that have resolved. That I think offers some guidance. The 9/11 cases where people got cancer from being in Manhattan on 9/11, those cases are resolving. So those situations offer us some guidance, and then it's going to be a family's decision. Do they accept the offers that are made, or do they proceed towards a trial?